Page number 140, res judicata. So coming to the terminology of what is res judicata, res means subject matter, judicata means adjudged, means things have been decided. Okay, together it means things have been decided for this particular subject matter, or a matter has been adjudged, judgment has been passed. So we don't have to testify more in any other courts. Okay, in simpler words, a thing has been judged by the court. The issue before the court has already been decided by some other court and between the same party. Therefore, the court will dismiss this case because another court has already passed the judgment. Okay, an apt court has already passed the judgment, and again you can't try the same case. If you have got the judgment, you are not supposed to try for the same case between the same party in some other court. Okay, and res judicata, the doctrine applies to both civil as well as criminal legal systems. No suit which has been directly or indirectly tried in a former suit can be tried again. Any suit or any charges that has been tried once, it cannot be tried again. If you have got the judgment, that's it. That's the end of the story. You can't run behind all the other courts to try the same case. Okay. Objectives of res judicata. The doctrine is based on three maxims, which are as follow. The maxims are in Latin, but you will also find the meaning within the same sentence. Nemo debt bis vexari pro una et idam causa, which means no man should be vexed or no man should be punished twice for the same cause. Okay, no person, criminal or in civil cases, nobody should be punished twice for the same cause. That is the one main foundation of res judicata. Interest re publicae at set finis litem, which means that it is in the interest of the state that there should be an end to a litigation. A case should end. Court cannot waste all their hours and days on a specific issue over and over again. Okay, any case should there should come an end to it. Okay, that is the second foundation. That's the second maxim. Res judicata pro veritate occipitur, which means judicial accepted as correct. The judgment given by a previous court is correct. Okay, no other court can pass on over a previous court. Every court has a dignity and respect. All the other courts do have to respect that. So if a court has passed a judgment, no other court can open and try the same case. So these are the three main maxims under res judicata. So there is a section 11 under the Civil Procedure Code, CPC, which was passed in the year 1908, which is still followed. So res judicata under section 11 of Civil CPC Code, it is as follows. There must be two suits, two cases. One is former and one is the subsequent. It is the same case, only a case which was tried in the court, and again the same case has popped up. In that situation, we can use res judicata. Okay, so two cases has to be filed in different time periods. Okay, the parties of the former and the subsequent suit, or the parties under whom they or any of them claim, should be the same. For example, two neighbors were fighting over a case. Okay, and the court has passed a judgment. The same two neighbors have come again and fighting for the same case in another court. Okay, so the parties involved here are the same people. Okay, so so if res judicata has to be passed, parties involved in fighting a new case should also be the same. The subject matter of the subsequent suit should be identical. What was the reason of the case? Okay, what was the meaning of the case? What were the weightage of the case? Everything should be same in the first case as well as in the second case. The case must be finally decided between the parties. Parties has to decide who is the defendant, who will be the person who is a plaintiff and defendant, the parties will decide it. And it is the same for the subsequent case as well. The former suit must be decided by a court of competent jurisdiction. Some cases and some judgment, some courts cannot pass it. It is outside their jurisdiction. Okay. But if a court within their jurisdiction has passed a judgment, it is respected by all the other courts as well. Okay. For example, High Court has passed a judgment, Supreme Court will respect it. Okay. Parties in the former as well as subsequent suit must have litigated under the same title. Okay. For example, case again, XYZ versus the state of Rajasthan. Okay. It's the same case then and today. Okay. So under the same title, there is no other title. There is nothing more involved. It is the same case under the same title. They are fighting again and again in a different court. So in these kind of situations, res judicata is being applied. So that is the section 11 of CPC 908. They have mentioned these foundations under which res judicata can be applied. Next, coming to estoppel. Is it clear about res judicata? What do you mean by res judicata? Is it clear to all? The basis and the meaning of the res judicata. And there are certain areas, certain situations in which res judicata cannot be applied. Okay, certain situations. For example, if the law has changed, okay, you can fight the same case again. If the law has changed, if under fraudulence, under some fraud proceedings, the case was a judgment was passed. If this fraudulence is proven, you can reopen the case. Okay, so these are some of the exceptions in which res judicata can be it can be reputed. Okay, and sometimes if the court has passed a judgment without knowing that if it is under their merits or if it is under their jurisdiction to pass this judgment or not, if a court by mistake they have passed something like this, okay, again it can be revoked. Okay, it can be reputed. Okay, there are certain situations in which res judicata can be reputed. Next, coming to estoppel. The doctrine of estoppel is that provision which prohibits a person from giving false evidence by preventing them from making contradictory statements in the court of law. Okay, so it protects the evidence. It protects the victim or the plaintiff or defendant, anyone from giving false claims. For example, you are an employer or you are an employee of XYZ company. Okay, you cannot say in the court of you have worked for that company. Tomorrow you cannot say in the court of law that you are not the employee of that company. You do not know anything about that company because salary slips are available. Okay, the projects that you have been a part of, proofs have been available. Proofs are available. So based on these evidences, you cannot say that you are not an employee of so and so company. So that's an estoppel. So this is a doctrine that prohibits a person to lie, prohibits a person to give false evidence in the court. Okay, they cannot make contradicting statements. There is a proof that shows otherwise. They have to be accountable for that. They have to be accountable for what they say. Okay, so estoppel protects that. Objective of this doctrine is to avert the commission of fraud by one person against another. Okay, because when you are doing something fraud, you are cheating, you are saying something that is untrue. Estoppel protects the person. Okay, with the help of evidences, estoppel protects the person. They cannot make false claims in the court of law. This doctrine holds a person accountable for false representation made by them. If it is proven that they have said something false in the court of law, they have been fraudulent in the court of law, through estoppel, they can be punished. Okay, either through his words or through his conduct. If it is understood that the representation was false, okay, doctrine of estoppel can be invoked. So there are two types of estoppel: equitable estoppel and legal estoppel. What is equitable estoppel? Equitable estoppel is a defensive doctrine preventing one party from taking unfair advantage of another. Okay, when through false language or conduct, or a person to be estopped has induced another person to act in a certain way, which resulted in the person being injured in some way. Okay, because of you, you kind of made this action take place. Okay, you kind of you gave some false information to make others do certain things in a certain way. Okay, so you will be the person who will be stopped because of your false recommendations, or because of your false facts, the false intentionally giving false information. Others are suffered, others have suffered. Okay, so that is an equitable estoppel. So main types of estoppel, one of them is reliance-based estoppel, in which a party relying on someone, something, or the other party has done and said, and they have put the action. For example, patients are completely reliant on their doctors, on the treatment options and uh, procedures, etc. What the doctors may have said, they were completely reliant on the doctors. Okay, and based on the recommendations, treatment, and the advice given by the doctor, the patient had taken some drug or taken some medication, which which gave complications. Okay, so under doctrine of Estoppel, the doctor can be charged. Okay, so different types of reliance-based estoppels. One is estoppel by record. Estoppel by record. This frequently arises as an issue or cause of action, or judicial estoppel, in which there has been some judgments or orders which have been passed to prevent the parties from relitigating the same issues or causes or action. For example, there has been a record of payment done. Receipt is present. Okay, you cannot say that you didn't receive the payment because receipt was sent, payment was done. The UTR number, okay, the payment ID is, everything is present. So in the evidence of all this, you cannot say you haven't received the payment. So that is an estoppel by record, because there are records, there have been evidence, there have been records which make sure that judgment cannot be passed otherwise. Estoppel by deed. Situations where rules of evidence prevent a litigant from denying the truth of what was said or done. For example, in certain situation, if a doctor has been charged, okay, and in the court of law, it has been asked for a doctor, did the patient inform you about their previous allergy? Did the patient was truthful about their medical history? Okay, and if the patient was truthful, the patient has mentioned about the allergies, if it is recorded in the medical records, the doctor cannot say that he was not aware of, the patient hasn't informed anything. Doctor cannot say that. Okay, because by deed, the doctor has had took an action of inquiring about the family history, medical history, allergies, etc., and it has been recorded in the patient's medical record. And tomorrow, if the doctor says that I was not informed about anything, that's a lie. That's a false allegation. Then estoppel by silence or acquiescence. So this prevents a person from asserting something when he had the right and opportunity to do so earlier, and such silence put another person at disadvantage. Okay, you know that you had certain information, but you chose to be silent, and you kind of in a way allowed the other person to suffer. Okay, you know the harmful side effects of a drug, but you didn't inform about that side effects to the patient. Okay, you were very well aware of the side effects this drug or this treatment can bring, or this surgery can bring. Okay, but you chose to be quiet. You didn't inform the risk factors properly to the patient. Okay, so that is estoppel by silence. Then we have laches, estoppel by the after the litigant deliberately and avoidably delays an action so as to disadvantage an adversary. Okay, timely action was not given, timely treatment was not given, patient was kept held up, Patient was kept in the waiting. Usually, most of the emergency ER cases where doctors tend not to attend the patient at the right time, treatment was delayed, care was delayed, and that caused complications or death. Okay, so in that cases, latches can be applied. Legal estoppel, so the estoppel of deed and estoppel by of record, which we have discussed earlier. Everything that is recorded, written down, okay? And if it is written down, you can't go against it, okay? If it is written down, you cannot say that it was not informed. You cannot go against it. You can't go back from it if it is recorded. And estoppel by deed, the actions that you took, okay, it puts someone else in disadvantage. Okay, you cannot go back from that as well. Okay, so these two estoppels are applied in legal estoppel. Then we have sine die. So sine die, it's an adjournment when the court adjourns, ends for the day. Okay, it can give us another date or timing for the second hearing. But sometimes the court does not give a time and date for the second hearing. So it adjourns with sine die. Okay. So sine die, the literal meaning for sine die is without day, which means without assigning a day or time for a further meeting or hearing. Because every time if a court case ends without without any judgment, they have to move the judgment for some another day. Okay, and that day and time is usually mentioned by the court of law. But if sometimes the court of law cannot decide the day and time, okay, at that point of time, sine die is invoked. To adjourn an assembly, sine die is to adjourn it for an indefinite period. Okay, you do not give you do not give this many within this many months or within a year, within this week or something. You are not giving such limitations. Okay, it will be adjourned for an indefinite period. A legislative body adjourns sine die when it adjourns without appointing a day on which to appear or assemble again. Okay, so you have to be kept up with you have to make a personal appointment with the judge and take a date later on. Okay, or you may have to come up with more evidence to fight the case again another day, and that day will be judged by given by the court of law. Okay. So in which situations do you apply sine die? A court can also adjourn a matter as sine die, which means matter has been stayed. Okay, the court has ordered a stay right now. Okay, but that's how we say in Indian language. We have got a stay order on this case. So stay order means if things goes as it is, there is no change. Okay, until further notice. Stay order is there until further notice. The various reasons that could be the cause of sine die are if the wrong procedure is followed, the way how proceedings are taking place, or the way how the legal procedures are followed, that is found wrongful. Okay, not humanitarian. Okay, it will not give it will not come out good for the victim, whoever is the victim here. So in case of wrong proceedings or wrong procedure, if it is followed, the court will adjourn the case for that particular day with sine die. And second situation, if the proceedings are not possible in the foreseeable future, okay, you may have to wait for an event to take place to gather more evidence, and then you can continue the hearings. Okay, in such kind of situation, in the near future, you know that proceedings will be futile. It will be a complete waste of the court's time and resources. So why to waste that? Let the proper event take place, and then we will decide a date and time to continue the hearing and judgment. Okay, so if the proceedings are not possible in the near future because of various factors, environmental factors, calamities, or evidence not available, witness is not awake, or witness is in a comatose situation in hospital, the witness is not awake, or witness has passed away, etc. In these kind of situations, it is an unforeseeable future. So the court will adjourn the case with Sine time. So we have discussed three topics today: res judicata, estoppel, and Sine time.